So tonight we discuss many different aspects of the criminalization of HIV non-disclosure. We discussed about the law, we discussed about the difficulty of applying the significant risk test, we discussed about the science, we discussed about policy consideration, the impact of criminalization on people living with HIV, and public health. And now I would like to turn our attention to one of the ways we can respond to an increased use of the criminal law against people living with HIV. And one of the ways to help ensure that when the criminal law is used, it is being used in a fair, consistent, and restricted manner. And more specifically, I'm going to talk about the development of prosecutorial guidelines in cases of alleged HIV non-disclosure. This is something the Ontario Working Group on HIV exposure and criminal law has been calling for in Ontario, but we are hoping that it can also happen outside Ontario in other provinces in Canada. So the Ontario Working Group on criminal law and HIV exposure is basically a group of people living with HIV, service providers, lawyers, academics, who came together to find a response to the criminalization of HIV non-disclosure. So first, I need to explain for those who in the room who may not know what prosecutorial guidelines are. And so basically, they are issued by the Ministry of Attorney General to help and assist Crown Counsel in their decision to prosecute on a case. So as you must have understood so far, Crown Counsel are lawyers who are responsible to prosecute cases. So they are basically taking the cases to court. Guidelines are issued as well to promote high standards and consistency in how the criminal law and cases are handled across one province. So they've been issued in many different type of cases, usually complex and sensitive one like domestic violence or sexual offenses, both in Ontario but also in BC. And as well as it's mentioned actually in the BC policy manuals, because they are a public document, they are also helpful in understanding how prosecutorial services are provided in the public interest. So an important thing to know about prosecutorial guidelines is that they cannot change the law. So it's only one part of the solution in restricting the use of the criminal law against people living with HIV. Only Parliament or court can actually change the law. But they definitely can affect the way the law is being applied and the type of cases that are going to courts. So guidelines do not apply to police, or at least prosecutorial guidelines do not apply to police, they do not apply to judges, but because of the key role that Crown prosecutors is playing, they definitely can influence police practices and in case that are going to court, because it is the Crown that decides to take a case to the court. Finally, the guidelines do not take decision-making responsibility away from Crown counsels. They have a discretion in the exercise of their power, but they can provide a policy direction. For example, in Ontario, in sexual offense cases, the guideline says, sexual offenses present an ongoing serious threat to public and individual safety. It is essential that the sanctions of the criminal justice system be fully utilized through the vigorous prosecution of provable offenses. So basically, they are calling for aggressive, prosecutions. So what about guidelines in the context of HIV or other sexually transmitted infection? It's not just the idea of the Ontario Working Group to develop such guidelines. Such guidelines actually exist. It's not a new idea. It's been developed in England and Wales in 2008, and they have their very detailed and updated guidelines that describe very well all the different steps and the medical evidence that the Crown has to have before making the decision to prosecute a case. The only province in Canada that have guidelines is actually BC. The guidelines were developed in 2007, but they don't say much. And they mention that there must be a significant risk for a case to be proved. But they don't say anything, for example, about what type of medical evidence the Crown must gather before deciding to prosecute a case. So why do we need, and why are we calling for strong and comprehensive prosecutorial guidelines in cases of HIV, but I would say also in cases of other sexually transmitted infection? We are only talking about HIV tonight, but the law could also apply to other sexually transmitted infection. But so far, for some reason, HIV has been singled out. So we believe that it should not be the case, and that if guidelines are developed, they should also apply to other sexually transmitted infection in cases those cases arise. So there are different reasons why we need guidelines, and I think you've seen that before in previous presentation. First, we need consistency in the use of the criminal law. As mentioned earlier, the law is quite uncertain, the significant risk test is vague, is difficult, and it has been applied and interpreted inconsistently and sometimes within the same province. So we believe that having guidelines for Crown prosecutor and setting standards would actually help ensure that cases are handled in a consistent manner. Secondly, as we mentioned earlier, there is a very poor understanding and appreciation of the risk of transmission and what is HIV in general among the general public, but also the legal professional. They are not different, and both lawyer, Crown prosecutor, and judges may not know anything about viral load and all these different issues. So this, in addition to all the fear, the stigma, and the prejudice that is related to, that goes with HIV, as we think, contributed to an extensive use of the criminal law. And we hope that some prosecutorial guidelines can bring some rationality in this prosecution and actually help avoiding having cases where there was no risk of HIV transmission. And I must say that in Ontario, we've seen cases where even the legal test of a significant risk have not been raised. They only looked at whether the person disclosed and whether sex occurred. No detail about what happened. And actually, in that case, a condom was used. So this is to give you an idea of how things happen there. And as Richard mentioned before, one person has been prosecuted for performing oral sex, and we know that this is negligible, if not no risk of HIV transmission. The third reason would be that these cases are very complex and highly sensitive, and this is why they require a good understanding of the science related to HIV, but also all the social context related to HIV. I think Crown prosecutor and legal professional in general have to be very aware of the stigma and the discrimination and the difficulty around disclosure as well, and all the reason why someone would not disclose. We hope that developing guidelines may actually be an opportunity to raise this awareness around the science around HIV, but also all the social aspects surrounding HIV. Finally, I would say the serious consequences of these charges, both on people living with HIV, even if a case actually ends up to an acquittal, it can have very serious consequences on the life of the person, especially if the picture of this person was in the media, if there was a police release and everybody knows about this person's status. This person's life can already be ruined, or this person may have been detained in pre-detention. And all the stress, the anxiety, and all this may have an impact on the health of this person as well. And then there is the impact on the public health that we have already raised, and I don't need to raise it again. So what did we do in Ontario? In Ontario, the working group has launched a public campaign, and we called on the Ministry of Attorney General of Ontario to develop prosecutorial guidelines in cases of HIV non-disclosure and other STIs. We organized a very big consultation with people living with HIV, service providers, lawyers, medical experts, scientists, women working in sexual assault, So lots of people. And based on this consultation, we drafted recommendation for the Ministry of Health in general. So I won't have time to develop all this recommendation, of course, but I brought a copy of the report that we gave to the Ministry of Attorney General, and it's at the back, and I invite you to have a look. So I just highlight some of the main recommendations. One is that we are recommending that the policy of the guidelines indicate that prosecution involving allegation of HIV non-disclosure or other STI should be conducted with caution and restraint. Guidelines should acknowledge that HIV prevention is primarily a public health issue. And so the criminal law should only be reserved for the most blameworthy cases. And I know Dickie said this is the case, but this is not always the case. And we saw cases where people have maybe one incident of unprotected sex and they were still prosecuted. Another very important point is that the guidelines should draw a distinction between cases where sex is said to be non-consensual because of the HIV non-disclosure, and cases that are indeed non-consensual because it's forced sex, coerced sex. And the fact that we apply the law of sexual assault makes this distinction very small. And so we are recommending that actually Crown prosecutors don't treat these cases of HIV non-disclosure when there is no coerced or forced sex the same way they are treating forced sex or coerced sex cases. And so they should not apply the policy that applies to sexual offenses that I mentioned earlier. Or they should also maybe consider laying lesser charges that have less implication for people. Because if someone is convicted of a sexual offense, it may be registered as a sexual offender for life. Another recommendation is to remind that there must be a significant risk of HIV transmission. Again, this is the law, and sometimes Crown just forget about the test. Again, I'm not talking about the Crown of BC, but we've seen that in Ontario. And so they should, because they are the one who have to prove that there was a significant risk of HIV transmission, we believe they are the one who have to bring evidence about that. And so they have to obtain at the earliest possible occasion a clear, complete, and accurate scientific medical opinion from a properly qualified expert. If there is no significant risk of HIV transmission, the charges should be dropped. So that's very short description of these cases where we believe, based on the current law, the charges should be dropped unless there is clear expert evidence to the contrary. It's oral sex, it's cases where condom was used, it's cases where a person had an undetectable viral load at the time of the sex. As mentioned earlier, before prosecuting, Crown must show that there is enough evidence to prosecute the case, but also that there is a public interest. And so we listed some of the factors that maybe the Crown might want to take into account when looking at the public interest factor, including whether that was an isolated incident. Maybe the person never went through the public health, scheme, and there was absolutely no intervention made by public health, and suddenly the person is caught by the criminal justice system. Maybe there is a better way to deal with this person. So the Ministry of Attorney General of Ontario has agreed to draft guidelines, which is a great news. We gave our report in June, but still we haven't seen guidelines. So it's very important to just remember that in the meantime, more people are being charged. We see more people, new people having their picture and health information made public, and we continue to see misinformation about the law, what's the test, and also about the risk of HIV transmission continue to spread as well. So we really need to do something. And action is not only taken in Ontario. We've seen that in Quebec there is an ongoing discussion between the public health sector, the justice system sector, and the HIV community. led by actually the COCSIDA. And now I'm turning to Janet Dickie and Jason Gratl, who maybe wants to talk about what's happening in British Columbia.